I don't know if you want to say we're all being recorded or.
No,
but-
I mean,
Okay.
basically,
But now I've
this is
said
Judge
it.
Stamey with Kevin Caden. Mr. Caden asked if he recorded the proceeding. I said, fine. Mr. Lambeck has no objection.
I
So
appreciate
we
that.
all are on board that this is being recorded. Anything else from the plaintiff before we get started?
The only thing was, because Abby Caden is not here,
Right.
I didn't know if I had to bring the power of attorney. I filed it.
I did see it. No, sir.
I did, if I may, Your Honor, want to clarify that power of attorney in this regard does not mean that Mr. Caden, who is not an attorney, that he is representing another person in this matter as an attorney.
Sure.
And that does not extend to him the ability to represent her in a court, because otherwise that would be the unlicensed practice of law.
Sure. Yeah, you're not being her attorney. You're just speaking on her behalf, and
Right.
we do from time to time throw that around that, oh, if you have a power of attorney, but candidly, I've seen case law from other circuits, in their
Okay.
appellate capacity that said a power of attorney isn't good enough for covering for someone, say, for to avoid a default. But to answer your
Okay.
question, no, sir, I don't need it. You've already filed it, but,
I just didn't want there to be any problems that she didn't show up.
oh, no, sir.
Okay.
No, sir. No, I have no problem. Mr. Lambeck, you have any problem with the fact that she didn't show up?
Not for the purpose of today, no.
Yeah. Anything else?
That's,
Mr. Lambeck, I did see your defendant's notice of filing supplemental authority. Anything else other than that?
No, Your Honor.
Okay. Well, fellas, I don't want to have been accused of being long-winded. I try to not belabor the point because I didn't schedule this for a lot of time. So I'm going to try to cut to the chase. I just want to let you know, after we had our last hearing, I asked, I hope you understood, for more time because my background is not in civil law. I went to law school and learned contracts and stuff like everybody else, but my background is not civil law, and I wanted to take a long, deliberate time to read everything and digest all this. So after our last gathering, when we had the actual hearing, I went back and reviewed Mr. Caden's, it's fair to say, for small claims matters, it's a lengthy statement of claim with attachments. After reviewing that, I reviewed Mr. Lambeck's defendant's motion to dismiss and incorporate a memorandum of law. I reviewed Mr. Caden's objection to motion to dismiss, as well as his copy of his presentation that he did the last time we were here. Went back over that again. And then I started rolling up my sleeves and getting into the heart of the matter, which was looking at the case law. I did print up several of the cases cited in the memorandum of law by the parties, and let me just tackle it this way. The first issue I wanted to address is the co-defendant, Ms. Andrea Small. Mr. Lambeck in his motion to dismiss kind of tackles that one first as well in his under argument memorandum of law. But the first entry is official capacity claims against defendant Andrea Scott are redundant as the city is also named as a defendant. The big case that I pulled up and read in its entirety was Braden Woods Homeowners Association versus Mavard Trading Ltd, found at 277 Southern 3rd, 364. It's a Florida Second DCA case from just a few years ago. I read that. Important parts that I came up with, I'll just read some excerpts from it. A suit against a defendant in his official capacity is, in actuality, a suit against the governmental entity which employs him. It cites Stevens versus Gohagen, 702 Southern 2nd 517, also a second DCA case. It goes on to say, analyzing state law claims as being against the defendant, city, and dismissing the claims with prejudice against the officers in their official capacities. That is also a Geidel versus City of Bradenton. The court stated that because suits against a municipal officer sued in his official capacity and direct suits against municipalities are functionally equivalent, there no longer exists a need to bring official capacity actions against local government officials because local government units can be sued directly. Quoting Busby versus City of Orlando 931, Federal Second 764 out of the 11th Circuit in Atlanta in 1991. After reviewing this case and reviewing the facts of this matter, I do agree with Mr. Lambeck and the defense that although it's not always a must, there are some exceptions, especially when the interests are counter to one another. But in this particular case, like the case of Braden Woods, which they say have filed joint brief and make the same arguments, and similar to this one. The city and Mrs. Scott have Mr. Lambeck representing them. Their arguments are kind of intertwined one with the other. I do find that having Mrs. Scott as a defendant is redundant, because she's working, her role in this is as an employee for the city and the Lakeland Electric. So I'm going to grant the motion to dismiss as being redundant to Andrea Scott. That's the first thing I wanted to do. Having done that, then I started tackling the rest of the case law and looked at the evolution of this. And I think the first case that was important is a Florida Supreme Court case, Pan Am Tobacco, 471 Southern 4. It's a Supreme Court case, and that's kind of the one that kind of really set the tone. In it, there you had the Department of Corrections that engaged in an express written contract with a vendor to sell tobacco products in various Department of Correction facilities, and it was an express written contract with all the obligations both sides had. They went into great specifics as to how someone could terminate the contract and what the consequences were. And of course, after the DOC terminated the contract, Pan Am Tobacco sued, and the result of that was this ruling, which in Florida, sovereign immunity is the rule rather than the exception, as evidenced by Article 10, Section 13 of the Florida Constitution. Provision may be made by general law for bringing suit against the state as to all liabilities now existing or hereafter originating. Probably the most important part of this opinion is the very last thing that the Supreme Court said. We would also emphasize that our holding here is applicable only to suits on express written contracts into which the state agency has statutory authority to enter. Accordingly, the decision of the district court is quashed. In this case, is remanded for further proceedings. So that kind of got the start, and then just to quickly tell you some major parts of other cases. City of Gainesville versus State Department of Transportation 778519. Again, they're kind of repetitive, but absent a written agreement, however, a vendor cannot sue the state for money damages on a contract theory. Also, it says, instead, we held that failure to allege the existence of an express written contract was properly considered on the motion to dismiss. Moving on, I read the case of City of Miami firefighters, police officers retirement trust, and versus Lieutenant George Castro. This was an interesting case, candidly. It was very interesting in that this had to do with pensions. You had police officers, firefighters in South Florida that after the housing collapse in 08-09, the state changed a lot, and the city of Miami changed a lot of how the pension plan was going to be administered and what the benefits were. And these folks down there that were getting ready to retire, they went and talked to someone that was on the pension board who gave them some advice. Relying on that advice, these folks retired early, or retired and went into the drop program, and come to find out that was bad advice. And so they sued, trying to basically say there was a contract, you're supposed to provide me with good information, and the District Court of Appeal in the 3rd District gave an opinion that was just contrary to that. Let me read it and tell you. It says, unless the immunity is waived, government entities in Florida generally are sovereignly immune from suit. In the contract sphere, the limited waiver of sovereign immunity is founded in common law and occurs only when the municipality breaches an express written contract. We view the sovereign immunity doctrine as designed to preclude liability for such conduct. They cited the City of Dunedin versus Pirates Treasure, Inc., holding that in the tort context that municipal sovereign immunity is not waived, making a big distinction between tort law, liability, and contract law. So that one was interesting to read. And then I got into one that really was Mr. Landbeck's, he specifically sent me a copy of it in his supplemental authority. And this is a hot off the presses case from the 6th District Court of Appeal from early last year. And it is the Polk State College District Board of Trustees versus Chantrell Fisher. And if you hadn't had a chance to read this one, this has to do with COVID. I thought it would be very applicable to what we're talking about here today. And that was, this wasn't the only suit in the state. I remember seeing some headlines. There were very similar claims around universities around the state. But when COVID happened and students were told don't come to campus, afterwards they sued because they're saying, hey, we paid some fees to use certain facilities, you know, the gym and other things. You charged us fees and then you told us don't come. We started a class action suit because you had a contract with us and you breached the contract and we should get our money back. And the long and the short, without belaboring the point, is Judge Stargell, writing the opinion for the 6th DCA, said no. And some pertinent parts are outside of claims brought under the federal or state constitution, sovereign immunity bars suit against the state. This is an absolute rule with only 2 exceptions. The first is in Florida's Constitution itself, which expressly vests the legislature with the authority to waive the state's immunity by general law. The second exception is of judicial creation. When the state contracts with a private entity, then the defense of sovereign immunity will not protect the state from action arising from the state's breach of the contract. Breach of contract claims may only go forward against the state entities where the suit is based on an express written contract into which the state entity has authority to enter. Failure to establish the existence of an express written contract requires dismissal of the contract claim. And this is where Judge Stargell opines that while a student's relationship with his university is contractual in nature, it is an implied contract and not an express written contract. The terms of a student's contract with the university may be derived from university publications, such as the student handbook and catalog. Such publications are terms of an implied, in fact, contract rather than an express contract. The plaintiff in this particular case, Fisher, merely attached 2 schedules of fees, essentially invoices, and alleged that the schedule of fees constituted an express contract that Polk State breached. However, the invoices here, like the statement of charge in Goldstein versus University of Central Florida, do not contain any promissory statements on the part of Polk State. In other words, Fisher was required to identify written contractual language obligating Polk State to provide the services Fisher claims entitlement to in exchange for student fees, and that the failure to provide those services entitles her to a refund of the fees charged. Since the invoices attached to the complaint do not constitute express contracts, the remaining question is whether Fisher's reference to other written agreements that she may or may not have had. And that goes into where the judge in this case, Judge Stargell, said, hey, she may or may not have it. Let's let discovery uncover that.
Right.
And Judge Stargell says, no, you have to have it, attach it to your statement of claim. If you don't have it, you can't expect to engage in discovery and then uncover whether or not there is an express written. Long and short of it, I will say this. After the hearing, I was quite certain Mr. Landbeck was right. I was quite certain, but I wasn't 100% sure. Again, my background is not civil, and I wanted to go and read these myself. Having read all of these and looking at the context of all the factual scenarios and things of that nature, I'm even more convinced now that he's right. I don't know how, Mr. Caden, using the language here, I don't know how you can establish that there was an express written contract when the advertisements or the rebate information says things such as subject to change without notice, subject to approval. That just almost like with that language there, that's a high mountain to climb to try to say that it's an express written contract. And candidly, I don't think you have done that. I don't believe there's an express written contract. And based upon that, I do believe that Mr. Landbeck is right, that the city of Lakeland, Electric Department are insulated by sovereign immunity. And I'm gonna rule in the defense's favor, and I'm gonna dismiss this statement of claim of prejudice. Because I think that's what I'm obligated to do based upon these cases. Mr. Landbeck, if I give you some time, could you prepare an order to
Yes,
that
Your Honor.
effect? I mean, basically, it's, my thought process pretty much goes lockstep with your motion to dismiss as far as the logic. I think it is what it is. When we were last together, I kind of said, there's, in life, there's differences between can and should. This is one where frankly, the law tells me that the state, city, Lakeland Electric is immune based upon sovereign immunity. And my ruling is that there was no express written contract, and therefore sovereign immunity attaches. If I give you, how quickly you need?
5-10 days.
Yeah, sure. How about that?
That's fine.
10 days to submit a proposed order, and certainly Mr. Caden has an opportunity to see it and make any objections to it. Once I get it, if it's pretty much what I've just said, I'll sign it, give it to the parties, and I wish you both the best of luck.
And Your Honor, just for procedural clarification, so based, and this is for Mr. Caden's benefit, I'll prepare the proposed order, I'll submit a copy to him to review,
Sure.
and if he's got any changes or corrections that are not agreeable necessarily to the city, we have a difference of opinion, I will submit both to the
Sure.
court for your consideration as to
Yeah.
which version you'd like to use.
Yeah, I think that's fair. Like I said, usually the prevailing party customary
Right.
writes the order. I've asked Mr. Landback to do it. You have a dog in the fight, of course, as to if you disagree with how he presented the order, you can come up with an alternative. He said he's willing to do that with any changes and send it to me, and I'll make corrections as I see fit, and then sign the one that I think is appropriate. So,
In
Can
10
I ask-
days? Sorry, just 10 days?
if that's
For both?
sufficient.
Okay, yeah.
If that's
Okay.
sufficient, if you need longer, I
No,
don't mind giving you
that's
longer.
fine.
Y'all were both very patient with me, giving me time to review all this.
I was gonna ask about the email with Andrea Scott, because that was like a separate, and that is also, your ruling was not a, I guess.
I
Yeah.
struck her, or not struck her, I dismissed it based upon it being redundant.
Right,
Based
but-
upon the case law that was provided. And then since she's no longer a defendant, my ruling is that there's no express written contract, and therefore sovereign immunity is present here, and the defendant is immune from prosecution based upon that. So,
And that includes the email between me and,
but that,
Okay.
yep, that's my ruling.
Okay.
So, all right.
I just was, not, I guess, completely understanding, but
Have a good day, sir. Nice to see you both.